talk specifically about your primary constituency, the judiciary. What were some of the innovations and reforms that you and your colleagues made in that regard?
Well, very briefly, we thought that the judiciary needed to be federalized, first of all. Our Supreme Court is overworked. It's the General Appeals Court as it stands, where everything and anything goes there. Two people are fighting over a 50 by 100 plot of land anywhere in this country. A dispute over it goes to the Supreme Court. Two traders are fighting over the delivery of a truckload of rice. It goes to the Supreme Court. Two brothers are fighting over a small house somewhere in Benin as to who should inherit. It goes to the Supreme Court. Somebody's fighting over a mosque in Lagos, who should control it, or a church. It goes to the Supreme Court. So to that extent, you also have constitutional matters between states and the federal government, civil liberties, issues of civil liberties, public law issues that will impact the polity. They're also struggling for space in the Supreme Court. We now said, look, let us give states their terminal courts. When I first suggested it, I said it should be state Supreme Court, but I couldn't get the consensus in my committee. They said, rather than having state Supreme Court as you have in the U.S., let's not have any court that will have the appellation supreme. Let's call them States Court of Appeal. It's okay. I mean, it's the substance that matters. Now, States Court of Appeal, will be terminal courts for states. All state matters will end there. Now, of course, there may be appeals from there. When they go from there straight to the Supreme Court. But they can only go to the Supreme Court with leave.
Of the Supreme Court.
Yes, with leave of the Supreme Court. So what you have a situation whereby, there's going to be highly reduced payload of work going to the Supreme Court. All this mishmash of cases that should be dealt with at the local level, state matters, we no longer need to find their ways in the Supreme Court. Now, if the appeal for it to be worthy of consideration for leave to go to the Supreme Court must be of grave constitutional significance or overwhelming public importance, the Supreme Court will be the exclusive judge of that. So when you have that, the load is bound to reduce. We will no longer have a General Appeals Court for a Supreme Court. We have a real court. Maybe there will be need to reduce the court, the size of the court, so we can have a court that sits as one at all times. It will be a truly Supreme Court. So that has been done. Then, in trying to integrate and solve the issues of the independence of the non-independence as things stand of the judiciary, we felt that, look, an office of an independent accountant general be created, because the issue of the independence or dependence of the judiciary to the executive is mainly financial. That is what ties that institution to the apron strings of the executive. Now, if we have an official who is a public official, you create an office of the accountant general, independent accountant general. You remove the accountant general from being a permanent secretary in finance ministry, whether center or the state. You give him a tenure of 6 years, a single tenure, a qualified person for that. The qualifications will be prescribed. A single tenure. You cannot entice him with another, do this for me, or behave well, and I give you another tenure, renew your tenure. Or you can also remove him the way you like, because he's independent.
Who appoints him?
He's nominated for appointment. The governor, the president may do that. But that does not impinge on their independence. The president appoints Supreme Court justices. Are you saying because of that they're not independent? The president appoints the chief judge of the Federal High Court. Should he not be independent after that? The president appoints the president of the Court of Appeal. The president appoints the chief justice, just subject to the approval of the Senate. So whoever appoints becomes unimportant.
With all these reforms that the council has put in its reports, is there a time limit within which it must be implemented, discussed?
I don't think we talked about time limits. But where things...
hold on. Only at the discretion of the president.
No, please. That is something I must tell Nigerians not to have, an attitude that will say, okay, it's not my business, it's the president's business. Well, Nigerians, when we're talking about the soul of our country, we're talking about moving ourselves forward. The president probably will be there for a few short years, and he goes away. What we've done should be X-rayed. And vetted to the extent that you come to the conclusion that what we've done is a good thing. then you need to help in sensitizing and mobilizing Nigerians that, look, this is the way to go. Then people should go back to their peoples, conferees, political leaders, whoever, church people, Muslim leaders should go back to their people and say, look, some good thing that just happened in Nigeria. The president made it happen. I think it is incumbent upon us, to bring it into effect.
If you want to know what's trending or you miss your favorite live shows, you can watch it all on our YouTube channel. Simply log on to www.youtube.com/channelsweb. Scroll down to your favorite program and click play. You can also view all uploaded videos by clicking on View All. Don't forget to subscribe and get the latest videos. If they are interesting, like them and be heard. Get connected with the Channels Television YouTube page. The news at your fingertips.
The Nigerian Bar Association ended its annual general conference in Owerri, Imo State on Friday, the 29th of August. On that last day, former President Okewale SAN gave his valedictory speech, after which he was given a Medal of Service and his administration was dissolved. The major highlight of that closing ceremony was the swearing in of a new administration led by Augustine Alege SAN, the 27th president of the NBA.
The new president, in his inaugural address, talked about some key things that should interest all lawyers. He set up a committee to see to the proposed amendment of the NBA Constitution, which will look at the key issue of introducing electronic voting. He announced that pre-registered observers would now be allowed at National Executive Council NEC meetings. The pre-registration would be available to verified lawyers who have paid their bar practicing fees and branch dues as at when due. Such verified lawyers would also be issued, free of charge, an NBA identity card which can serve as a payment card for ATM, POS, and online transactions, and would entitle the holder to discounts on packages negotiated by the association. One of such packages will be the NBA insurance policy, which will provide insurance cover for all lawyers who have paid their bar practicing fees as at when due. That's not all. There's a proposal of a 10% reduction across board in respect of the bar practicing fees and 40% reduction of the fees for the 2015 Annual General Conference. For the branches, there's a proposal that their share from the practicing fees should be increased from 10% to 20%. The additional 10% to branches would be applied to set up a Lawyers' Welfare Trust Fund at all NBA branches. The new president also talked about disputes arising from branch and section elections. In the case of the Section of Legal Practice, SLP, he nullified the current leadership and appointed Mr. Jide Koku, SAN, as the interim chairman of the section, with a mandate to run it until proper elections are held within 6 months. Ahead of the 2015 elections, the president also set up a committee to be headed by former President J.B. Daudu, SAN, to organize voter education and help the association drive its new area of engagement in the electioneering process.
And this is where we end today's episode of the program. These and past episodes are on our YouTube page. And do let's interact via Facebook, email, or Twitter. I'm Shola Shieli. Thank you for watching.